2024 TO 22, State of Kansas versus Danny Johnson, County Attorney Jill Gillette for the state. Mr. Johnson appearing in person and pro se. Your name tag on your uniform says Johnson, so I presume you are Mr. Johnson. Now, sir, if you could get right in front of that microphone, thank you.
Can you hear me?
I can. Sir,
yes.
You're charged in count 1 with speeding 82 miles per hour in a 65 mile per hour zone. That is a traffic infraction. It is not a charge that carries any jail time. It has a scheduled fine. 82 and a 65 is $87, but then there's also 108 court costs. In count 2, you're accused of operating your motor vehicle without proof of insurance. Now, if you had insurance but just couldn't find it, you can get the proof to the county attorney and she'll probably dismiss that charge. If, in fact, it had lapsed or something was happening so that you didn't have insurance on the vehicle at the time being January 4th, 2024, that is a B misdemeanor. The maximum penalties as far as jail time would be 6 months, although probation is usually granted. There is a mandatory minimum fine the court must impose of $300, but it could be as high as $1,000. You do have the right to hire any attorney of your choice. If you cannot afford an attorney, you can apply and see if you qualify for court appointed. You can waive your right to counsel and represent yourself. Another option, you might be able to apply for diversion. That is where you apply, and if the county attorney approves you for diversion, you would pay agreed upon fines, costs, get your insurance current, and pay a diversion fee, and she'd dismiss the charges and keep them off your record. If you want to talk about diversion or anything else with your attorney, you certainly will have the opportunity to do that. Your pleas, you have a choice of pleas. You can plead not guilty and we can set this for trial at a later date. You can plead guilty, admitting the charge, and we would proceed with sentencing. Or you could plead no contest, which is neither admitting nor denying the charges, but you'd still most likely be found guilty and we'd proceed to sentencing. If you want to look into diversion, we'll enter a not guilty plea to give you time to do that. You can always change your plea, but once you're convicted, pre-trial diversion is off the table. So
probably not eligible for diversion based on his driving record.
Oh, okay. Well, do you want to talk to an attorney then and discuss whether or not you have a defense? Or?
No, Your Honor, I would like to request a declaratory judgment due to there is no agreement.
We are not under the impression that the American people need your approval of the law, because personal agreement has never been a requirement for legal obligation. The moment you leave the privacy of your home and enter the public domain, you become subject to the same rules that govern everyone else. These laws exist to preserve order, safety, and fairness in society, not to accommodate individual preferences. The social contract applies equally to all citizens, without exceptions or special interpretations. Whether you like the law or disagree with it is beside the point. Participation in public life carries responsibilities along with rights. Those responsibilities are not optional or conditional. Compliance is required, regardless of personal belief.
Well, Your Honor, I simply do not understand the nature and cause of the accusation with regard to the jurisdiction of the venue and nature of this action until the prosecutor properly alleges them there. I cannot enter a plea to the charge until I have the opportunity to raise a meaningful defense on my behalf.
All right, I will then, since you cannot enter a plea today. I will enter a not guilty plea for you and give you
I
time.
object, Your Honor. I object to you entering a plea to me because I must understand the nature and cause of these accusations. So I do not agree to you entering a plea on my behalf.
Well, your position is taken and I'm still going to do it. I will note your objection for the record, but I'm going to enter a not guilty plea.
Well, I object to you entering
Your
a plea
objection
on my
is
behalf.
noted. Your objection is noted, and if the time comes, you can appeal that to the Court of Appeals. Now, on the issue
Well,
of the attorney.
Your Honor, I would like to ask, who bring these charges against me? I should have the right to
All
question.
right, we're not going to have this debate right now. I've told you your charges. I've told you the state of Kansas has filed those through its attorney, Jill Gillette. Now,
Well, I would like to call the state to the. I would like to call the state to the stand, Your Honor.
We're not doing that,
state bringing charges against me. Who is it? How did I injure the state?
All right, this is your first appearance. I advise you of your rights. I advise you of your charges and possible.
Your Honor, I object to the proceeding, for I do not know the nature and cause of the
I'm
proceeding.
entering a not guilty plea. Missy, when is?
I object to you entering I object to you entering a plea on my behalf. I do not grant you that right.
Missy?
The court date.
You're supposed to act as a trustee.
Sir, you need to stop. You're being.
What truly confounds me is that Judge Webster repeatedly gives him every chance to walk away. Yet he treats the entire situation like a game. To him, the courtroom is not a place of consequences, but a contest to be played. He seems convinced that it is not over unless he wins with a dismissal. At the same time, he ignores the obvious alternative outcomes staring him in the face. This is not a game with imaginary stakes. There are real consequences attached to every choice he makes. The judge's patience has limits, no matter how generous it appears. And if this continues, the ending is painfully predictable.
Deputy Miles.
And also Article 3, the judge must operate in good faith and good behavior. So therefore, if you're making a threat towards me, then
Deputy,
that's
if he's going to
urging
keep
me to
being
perform in your
contentious, I'm going to
court.
have you take him into custody on contempt.
Then that would be illegal search and seizures, Your Honor.
Wouldn't you need to go back?
It will.
All right,
It's
Missy.
false
I
imprisonment.
want you to stop talking, or you can go upstairs to the county jail. Now, do you want to go to jail tonight?
Your Honor, again.
Deputy Miles, could you come in and assist the defendant?
September 27th at 9 o'clock will be the court date.
September 27th, you said 9 o'clock?
Yes.
9 a.m. You must be back here, sir, in person at the courthouse, or you will be arrested for failure to come to court. Now, that deputy there is going to take you into custody if you cannot control yourself through the remainder of this hearing.
I'm not doing anything. I'm just enforcing my right, Your Honor.
All right. So your first right is to have a hearing date, and that is September 27th, 9 a.m. The second
Your Honor,
right,
I also have a right to understand the nature of this. I have a right to understand the
all
nature
right.
of the cause.
If you don't want to listen to me, you can go to jail.
Is that your order, Judge?
Do you want to hire an attorney or apply for court appointed?
No, I do not. I don't need to hire an attorney, Your Honor.
You want to represent yourself?
I don't need to hire an attorney. I would like for you as the judge, Your Honor, to explain to me the nature and cause of these.
All right, I'm not going to appoint an attorney if you don't want me to. If you want, you said you don't want to hire an attorney. If you want to apply for court appointed, the officers have forms there that you can fill out.
I just want to understand the nature and cause.
If you don't want to fill one out, I'm going to assume you don't want an attorney. And then if you come to court September 27th at 9 a.m., you're going to be representing yourself if you don't hire or apply for court appointed. And so you've got the third issue. Does he have a bond? Looks like you do, because you failed to appear February 27th at your first appearance. So bench warrant was issued. Bond was set at $1,000 cash for professional surety. Looks like that was posted. Looks like you made a cash bond of $1,000. Does that sound right? You put up 1,000 cash back in July 12th?
I'm still trying to understand the nature and cause of this allegation.
You would first need to undo decades of misguided thinking, then actually commit to learning the law through proper education. Maybe after college and law school, you might begin to grasp the true nature of the charges being filed against you. The Constitution does not require the court to cater to confusion or denial. It guarantees only one thing in this regard: the right to be informed of the nature of the charges. That right does not include endless explanations or personal approval. Judge Webster has already fulfilled his constitutional duty. The charges were clearly stated on the record. Understanding them is your responsibility, not the court's. The law does not pause for willful ignorance.
In person, September 27th at 9 a.m. So you've got your court date, you've got your bond, and we've talked about your lawyer. Now, you're wearing a U.S. Army uniform with the name Johnson on it. Are you in or have you been in the United States military?
Your Honor, I'm still trying to understand the nature and cause of the allegation, Your Honor.
All right. If you can leave the courthouse now without any further disruption, I will let you do so. But I'm going to have those officers escort you to make sure you do so. So, Ms. Gillette, anything further?
Your Honor, it is your oath to explain the nature and cause of the allegation against me. Are you failing to do that?
All right. You can either walk out the front door with the officers, or you can walk upstairs to the county jail with the officers. The choice is yours. Either leave.
Your Honor, I'm trying to understand.
Disruptively.
I'm not being disruptive. I'm just trying to understand the nature and cause of the charge.
All right, officers. I'm gonna close.
What am I doing? I'm sitting here trying to understand the charge.
If he gives any more grief.
All I'm asking is to understand the charges. This is for the record. You said it's for the record, so I'm trying to understand what am I being charged?
The charges. Goodbye, sir.
I just want to understand the nature and cause of the charges, Your Honor. That's all I ask. It is your oath to give that.
With you. If you tell me what kind of questions you have, I'll be happy to answer them. But I've already told you.
Okay. Under what jurisdiction is these charges being brought to me under?
All the
State of
jurisdictions.
Kansas is charging
all
you
of them.
82 and a 65 and operating in a motor vehicle without liability insurance on January 4th, 2024 in Greenwood County, Kansas. You failed to appear for your first appearance, and a bench warrant was issued, and you were arrested, and you made a bond of 1,000 cash or surety, posting a cash bond. Now you have to go to court, and you have to answer those charges. You can
Your Honor,
have a trial if you like, and the burden will be on the state of Kansas to either prove or disprove. If they can't prove it beyond a reasonable doubt, you're let go.
Well, I'm still trying to understand under what jurisdiction am I being charged under, Your Honor? That's all I'm trying to understand.
You're being charged under the jurisdiction of the state of Kansas under its criminal.
But according to the Constitution, there are only two jurisdictions.
All right, we'll have that on a later date.
Yes, you can go home. If by home you mean the Greenwood County Jail in Kansas. If your goal had actually been to return to your real house, you had countless opportunities to do so. All it would have taken was following a simple instruction and staying quiet. Judge Webster warned you repeatedly, with more patience than most would offer. Instead, you chose to keep talking and escalated the situation yourself. Consequences followed exactly as promised. And as for your ever-present companion, she seems determined to join the spectacle. Let's see how quickly she manages to earn herself a cell as well.
I'm waiting on this, Your Honor, to explain.
All right, Missy. That's our last case on the docket, isn't it?
This is not good.
Yes.
All right. All right. Ms. Gillette, I'll see you at 3:30 docket.
Your Honor, can I please go home? Your Honor, Can I please go home? I'll leave.
All right. Well,
Can I go?
Well, this situation has suddenly become uncomfortable in a way no one can ignore. What began as tense has now shifted into something undeniably awkward. There is no graceful way to recover from this moment. The atmosphere in the room has changed, and everyone can feel it. Silence might have helped earlier, but that opportunity is gone. The consequences are now unfolding right in front of everyone. All attention is fixed on what happens next. And somehow, the awkwardness continues to deepen.
Can you hear me?
yes, but you're not the Johnson I was looking for, but I will take your case up. I have a Danny Johnson, and, well, don't I have her on here? Oh, she's Stasha Carter. Do you go by Johnson also?
Okay, so I'm here for Danny Johnson.
Oh, are you the attorney?
I'm a representative for him.
What does that
And
mean?
that means I'm his wife, and we sent
Okay, are you an
documentation.
attorney?
I'm an attorney in fact.
You're not an attorney at law?
No.
Okay. So when you say you're an
Mr.
attorney, in fact, you're not an attorney, but you're here on his behalf as a citizen. Is that
No, I'm
right?
not a citizen. I'm not a citizen. But let me state for the record, Mr. Johnson is under doctor's care. He's in recovery. We sent the documentation over to the courts to show that, to show proof of that. We also reserve our rights to any and all reproduction or distribution.
There he is, suddenly available and ready to respond. It's interesting how quickly his condition seemed to improve the moment a bench warrant was mentioned. Just moments earlier, he was unable to participate. Yet now he can answer the judge without hesitation. The timing speaks for itself. Accountability has a way of clearing up confusion. The authority of the court tends to eliminate excuses. When consequences become real, cooperation follows. It's remarkable how effective enforcement can be.
Right. Mr. Johnson failed to appear at his first appearance, February 27, 2024. August 13th, 2024, he appeared. We took formal first appearance. He entered a not guilty plea. Actually, he objected, I think, to just about everything that we did. He was argumentative, disrespectful, interfered with court proceedings. I believe he
I
was
object, Your Honor. I think he was
Stop. You don't have any standing here today, Miss Carter, because you're not his lawyer. You're not him.
I'm not Miss Carter. I'm not Miss Carter.
Then why does your screen say Sasha Carter?
That's what it says, but I'm not Miss Carter. And it says
Who are you? Who are you? Before I disconnect you from these proceedings, because you don't have standing to be here. What's your name?
Well, again, Mr. Johnson is under doctor's care.
Do you want to tell me your name?
He's here. I've already gave you my name, ma'am. I'm his
Well,
wife.
then say it
I'm
again,
Miss
because I
Johnson.
must have missed it. What's your
Miss
name?
Johnson. Miss Johnson.
What's your first name?
Nicole.
How do you spell that, please?
Nicole.
Nicole Johnson. And you said you're his wife. Is that
That's
correct?
correct. That's
You're
correct.
his legal wife. Okay. Now, if you'll let me continue, and if you won't, then we'll have to remove you from the proceedings. On August 13th, 2024, he became, as I said, argumentative, disrespectful, and interfered with the court proceedings. I found him in contempt. He was arrested, and he was to serve 24 hours in jail. And then, as I recall, the military put a hold on him, and because of whatever reasons, he served more than 24 hours. But he was told to be back here September 27. And on September 27th, there was an issue that he either was or was not receiving medical service, and he wanted a continuance, and we ultimately continued it to today. Now, that's been a month ago, and you say he's still under doctor's care and can't be here today, or is that, what were you trying to explain there?
What I was expressing, ma'am, is that he was in surgery on the day of the court date. He had
30 days
actual
ago,
surgery.
he was in surgery. Okay.
Correct. The doctor put him under doctor's orders to stay on bed rest. And that's where he's currently residing at, on bed rest. And we sent in the documentation to the courts and the doctor. The doctor notified the courts that he's not to appear because he can't travel and he can't fly due to his surgery.
And we've made it clear to him that he can appear by Zoom. So I'm going to issue a bench warrant, bond forfeiture.
Hold on one second, ma'am, because he is here. He can hear you, but
Put him on here.
Oh, he's on here, but he's in a recovery bed, ma'am, and it's a violation of his rights, his HIPAA rights, to be shown and be broadcasted all across social media as far as
bench warrant, bond forfeiture.
As the saying goes, those who walk into court together often end up facing contempt charges together. What starts as shared support quickly turns into shared consequences. Standing beside him has not spared her from the court's authority. In fact, it has placed her directly in its path. The judge's patience applies to everyone equally. One poor decision has a way of inviting another. And from the look of it, she is only at the beginning.